Thank you, everyone, for your punctuality and your patience while we're still allowing others to join as we make a start. So talofa lava and greetings to you all. My name is Su'a Helena Woolwork, and I'm the Attorney General of Samoa. I'm also the chair of the Sexual and Gender-Based Violence Working Group for the Pacific Islands Law Officers Network. I will be chairing this webinar today. Thank you for taking the time to attend this important webinar presented by the working group. This is the third webinar in our series, which focuses on the use of special measures in cases involving sexual and gender-based violence. We are honored to be joined today by two members of the judiciary, one from Samoa and one from Tuvalu, who will provide practical advice from a unique perspective. Our first presenter is Samoa Supreme Court Justice Tafaimaalo Leilani Tuala Warren. And our second presenter is Tuvalu Senior Magistrate Corina Ituaso La'afai. We are also joined by our graphic recorder, Jessamine, who will be drawing a live visual representation of our two presentations today. I will be keeping to time today. After both presentations, I will invite those that can to stay for a question and answer session. You can also post questions in the chat section during our presentations. There will also be a very short discussion after Justice Tuala Warren's presentation, if there is time, as she will need to leave soon after. And just quickly and briefly, for the benefit of newcomers, I will mention that when we talk about special measures, we are referring to practical tools designed to support witnesses to give their full evidence to the best of their ability in court. Giving evidence in court is stressful and can be daunting for many people at the best of times. So I'm very much looking forward to these presentations, and I hope you are too. On that note, please let me now invite Samoan Supreme Court Justice, Her Honour Tafaimaalo Leilani Tuala Warren, to share her presentation with us. Your Honour, you have the platform.
Madam Attorney, thank you very much for that introduction. And talofa lava, everyone, and thank you for the invitation. I do feel very honored to be able to share some of my experience from the bench in terms of special measures for vulnerable witnesses. All the special measures actually that I've seen in the model provisions have been encoded into Samoa's Evidence Act in 2015. Now, perhaps Madam Attorney may correct me, but our legislation does not define vulnerable witnesses. So judges have the discretion to consider things like age and maturity of a witness, their physical, intellectual, psychological, or psychiatric impairment, any trauma, their fear of intimidation, their linguistic, cultural, or religious background, nature of the evidence they're expected to give, and their relationship to any other party in the proceeding. So these are some of the things we take into account when we are considering whether somebody needs the protection that can be offered by not only the special measures that are encoded, but judges' directions. Now, once we consider those factors, this will determine the special measures to be put into place to minimize stress on the witness and to promote the recovery of a complainant. And that's all whilst ensuring a fair trial for the defendant. Now, the special measure that I have used the most is the alternative way of giving evidence. There is a use of video link evidence, and there's a special room in the Ministry of Justice from which witnesses can give their evidence. There was a lapse in the maintenance of this room for a few years by the ministry, but I understand that as we speak now, they're giving priority to getting this room operational again. Now, whilst that was happening and that wasn't, we were not able to use that, we used an empty courtroom wherever we could find one. Now, most often the use of a screen blocking of the defendant, especially in sexual cases, is commonplace. I have had sexual offending cases with complainants as young as 4 years old. And even without a prosecution application for directions as to the alternative ways of giving evidence, or judges will make directions when witnesses of sexual offences give evidence, regardless of age. Often the adult female witness also requires a safe space within which to give her evidence. We have often prohibited publication of witnesses' names and any details which may identify him or her. Only once have I disallowed a self-represented defendant from cross-examining a complainant, and this is because defendants in the Supreme Court are charged with very serious offences, so they are often granted legal aid. So they have counsel to represent them. Often I've disallowed unacceptable questions from counsel, and perhaps 3 or 4 times I have disallowed evidence of sexual reputation and sexual experience. Overall in Samoa, the lawyers are respectful and sensitive in how they ask their questions to vulnerable witnesses, especially in terms of tone. As we know, lawyers can have very intimidating, loud tones when they speak in court. But I have noticed that I've been very impressed that when it comes to them questioning, especially child complainants, all have really been considerate and respectful in that way. Now, in most assessor trials of sexual offences, I have given directions to assessors about the manner in which evidence has been given. And where there is a delay in laying a complaint, I have directed them that there may be good reasons why the victim of a sexual offence may not make or may hesitate or delay in making a complaint. We also have a provision which allows for support persons for witnesses in criminal proceedings. And this is where, for us, Samoa Victim Support Group comes in. Often on our own initiative, that's the judges, we contact Samoa Victim Support Group to be present in court to support a complainant where they have no one present and where the person has not gone to Samoa Victim Support Group. But most complainants we have noticed in sexual offending cases are brought by Samoa Victim Support Group because they are often the first port of call before they then go to the police. So Samoa Victim Support will take their complainants over to the police station to lay a complaint. So this brings me then to Samoa Victim Support Group. It's an NGO which is instrumental in Samoa in supporting and informing the court about our vulnerable witnesses. We have a wonderful woman at the helm, Lena Chang, who helped us also to establish the Family Violence Court in 2013. Now, I don't think I would have been able to do it without her, but we are very pleased that as an NGO, I think this year's government budget was the first time that they have gotten some funds from government. So outside of court, we have Samoa Victim Support Group because there's no equivalent in our government, and we rely on them to take over once our vulnerable witnesses leave the courtroom. They have a shelter, they have a school for child victims, and a shelter for victims of family violence. Now, inside the courtroom, what do we expect from prosecutors? Now, we need them to alert the court to any special measures required before a case is heard so that we are prepared. And during the hearing, as matters arise, which require us to give directions. Now, this is mostly done really well in Samoa, but I often feel there should be special training for prosecutors and judges in this area, just as there should be special training for first responders in sexual offending and family violence cases, because the court completes the cycle of engagement for vulnerable witnesses with the justice system. And therefore, this is a final and a critical step for them. So there should be training for us as well. Thank you to Nick, who sent some questions to get me thinking about my presentation. And one of them was the impact of COVID-19 on the use of special measures. Now, because Samoa went into total lockdown, the courts couldn't operate because we were caught off guard. Slowly, though, we started to use video link more often, but that was only in relation to those who were in custody. So I can honestly say we are racing to catch up right now, so that if something like this happens again, we will still be able to conduct our cases. So because the courts came to a halt, the cases within which special measures would be utilized did not proceed. Now, the result is this year, we are trying to clear sexual offending cases from 3 years ago. And the difficulty is for the vulnerable witness is that a lot of time has passed, and there's a risk that the quality of their testimony is then compromised. So now, more than ever, we have noticed that the environment within which they give their evidence today is really important. Now, just specifically dealing with children who are vulnerable witnesses, we have our family court rules, which are quite extensive. I'll give you just a few examples of what we have in there. We have Rule 19, which deals with views of a child or a young person, and that's when the court can exclude lawyers from the hearing so that the judge can ascertain the view of the child or the young person. We also have Rule 27, which deals with the appointment of a representative for minor or incapacitated persons. We have Rule 87, which provides for telephone conference link-ups and video conference link-ups. We have the Family Safety Act, and that's designed specifically to deal with protection orders for family violence, for victims of family violence. We have Section 8, which also encodes that principle where if a respondent is not represented by counsel, they cannot directly cross-examine the vulnerable witness or the complainant. They need to write their questions down. It needs to be given to the judge, and the judge will ask the questions. It also encodes, for example, the use of a screen between the defendant and the complainant when she or he is giving evidence, and video conferencing. So these are things that have been slowly put into our legislation to enable us to be able to provide other means for our vulnerable witnesses to give their evidence. Now, it also provides, interestingly, for duties of police to assist and inform complainants of their rights, which I think is really critically important for our vulnerable witnesses, and imposes on them a duty to prosecute. Now, that is a whole nother presentation altogether. Now, there is a lot I could delve into in this area of the law, but I think that's probably best left to the family court judge. Suffice to say, in the last 10 years, the significant legislation has been introduced, which takes into account vulnerable witnesses. But I don't think it should stop there. I think as judges, we are proactive, and I'm proud to say we are proactive in finding ways to ensure that vulnerable witnesses are able to give their evidence in an environment which is not always the friendliest. Now, it is work in progress. And as judges and prosecutors, we probably should never stop working towards reaching a point with every vulnerable witness where they are comfortable to tell their story in an unintimidating environment. Because after all, that is why we do the jobs we do, to ensure that justice is done. That was it for my presentation. I was about to say, in conclusion, I thank you all for taking time out of your busy schedules to hear me share a little bit about what we do in Samoa. I hope it's been helpful in some small way, and I will take questions. I still have a bit of time, but in case I don't have the chance to say it, enjoy the rest of the webinar. Thank you to Nick and Chase and Sophie and for helping me to get to this point. I'm not the most technologically savvy person there is out there, but thank you for all your assistance over the past few weeks. I'm sorry I'm going to miss the next presentation. And I'm sure she will be amazing. But yes, I'm open to questions now. Thank you for your attention. God bless. And yes, question time if anybody has any pressing questions they want to ask.
Thank you. Thank you very much, Justice Tuala Warren, for that very interesting and such a fantastic presentation. I was particularly interested to hear from the judiciary's perspective that the lawyers in Samoa are generally respectful, sensitive, and considerate when it comes to cross-examining especially the child victim witnesses. So thank you for sharing that with us. It's also great to hear that there's been a lot of progress in the last 10 years in terms of legislation. And thank you for the encouragement that we shouldn't rest here. There's still a lot more work to be done. So on that note, I'll open it up to the floor. If there are any questions, if anyone in the audience would like to share any particular advice from Justice Tuala Warren you found helpful, or any particular questions you want to put to her honor while we have time.
Hope I haven't intimidated everybody into not asking questions.
It's because it was so clear, Your Honor.
Sorry about that, Echo. I have a question to get us started. Thank you so much for your presentation, Justice Tuala Warren. I know you said it's a completely different whole nother presentation, but I was wondering if you could talk briefly about the impact that you've seen on police having the duty to prosecute, what changes you've seen since that duty has been introduced.
Okay, that duty was introduced in 2013, and I think since then, the number of cases of family violence that we have seen come through the court has increased tremendously, to the point where we created a whole family violence court to deal with family violence. Because I think in the past, there was a lot of reconciliation that was conducted by the police themselves, which we did not think was their place to get involved in. We didn't think it was their role to play, because we needed people who had committed family violence offending to actually go through the system and try some rehabilitation. That's why the family violence, it is a unique therapeutic court. So we wanted to address the causes of the offending, have a holistic approach in terms of addressing the whole family so that they come out at the end of the engagement of the criminal justice system and there are changes made. So we didn't think the reconciliation done by the police was proper, because we then saw reoffending. But yeah, it's increased significantly the number of cases that have come through.
Thank you for that. And when you say you take a whole family kind of therapeutic model, what does that mean? What kind of measures are taken?
So for the family violence court, what we had was a rehabilitation program for the offender, which often included the spouse as well. And they would go through a whole process where, if provided that she was comfortable with that, there was nothing that was imposed on the families. It was only if the spouse had a desire to go through the program with the offender. So she would be there in support. Often it was a she. She would be there to support the offender. And that would take about anywhere from 8 to 12 weeks. And at the end of that program, it was called the Men's Advocacy Group, which was done through Samoa Victim Support as well. At the end of the program, there was a graduation ceremony where you have completed the program and now you are being acknowledged for it. And that just had a huge impact on the families, because I think the spouse, the children, they're all extremely proud in seeing these changes in their father often. And that's the process that we wanted all the offenders to go through, provided it was appropriate. So the family violence court's jurisdiction was the current district court jurisdiction, which is all the offences 7 years and under. I understand that jurisdiction has been raised now, but for 7 years and under. So we were dealing with the assault cases, the insulting words, the threatening words, any serious family violence offending would go to the Supreme Court, and that sort of therapeutic approach is not available here. So that's why that family violence court was important, and it's still going strong today with a different judge. Yeah.
Such an interesting model to hear about. Thank you. When you say provided that was appropriate, is that, as you say, based on the length of, whether up to the 7 years?
Yes, and where the spouse is willing to engage in the process. If it was, if she did not want to get involved in the process and she was leaving him, that's fine too. We concentrate on the offender, but we would never force her to be involved in a situation where she did not want to be involved any longer. So it was always a matter of appropriateness for the complainant.
Thank you very much. Are there any other questions from the audience?
Can you hear me?
It's 5 minutes, so we'll make use of that opportunity for a final question.
Kia ora, Leilani. Excellent presentation. Thank you very much. Here from the Cook Islands. Kia ora, everyone. Just a question regarding the rehabilitation. What success rate have you had during the rehabilitation?
Well, during the time when I was in the family violence court, which was from 2013 to 2016, beginning of 2016, our recidivist rate was less than 1%, which was quite an achievement. I'm not sure what it is now. I've been told by the current family violence court judge that it still is very low. But when we first started out, it was less than 1%, which was amazing considering the recidivist rate in Samoa. Okay,
it looks like everyone is well informed by that presentation. Thank you very much, Your Honour. I think it's I think we've now come to the time where we can say thank you very much for making yourself available. Thank you for the presentation. Thank you for your patience in answering the questions. And we can now say farewell. And we want to make sure we get that in before your registrar comes in that back door again. Thank you very much, Justice Tualamoana.
Oh, thank you, everybody, and enjoy the rest of the webinar and have a safe weekend. Thank you for having me so far.
Thank you, Madam.
So while we wait for people to vote, let us now check in with Jessamine, our graphic reporter, to see how the graphic illustrations are going. This visual representation of our speakers' presentations will also be emailed to you. Okay, so thank you, Jessamine, for that visual representation. We all really enjoy having this engaging record of our webinars. It's always fun seeing these presentations visually translated and to be done so quickly. Thank you very much for that, Jessamine, sorry. On that note, please let me now invite Senior Magistrate Corina from the Tuvalu Magistrate Court to share her presentation with us. Thank you very much, Senior Magistrate Corina. The platform is yours.
Thank you, Madam Attorney General Walwork from Samoa for the introduction and the facilitation of this webinar series. Thank you also to the Attorney General's team from Australia for the support in preparation for the discussion. Excuse me, I'll rather say it's a discussion because the poll does provide the rating standing at a discussion from the judicial perspective. So on that note, I would also like to thank Judge Leilani for the insights into the case of Samoa and the approach of Samoa in terms of the special measures introduced to the countries of the Pacific under Pilon. For my presentation presentation, I'll say it will be a very short one because I think I've put through some of the initial discussion through email via our friends or colleagues from the AGD in Australia. So basically, I'll touch base on three aspects of today's presentation, and that the first part is the role of magistrate or the courts in Tuvalu in as far or the extension by which we use special measures in terms of evidence collection and coming into court to give evidence. The second part will basically to answer some of the questions. I'll put that to the end, but the middle part, I'll specifically talk about the provisional special measures because some of them are relevant and equally important or crucial to the judiciary as much as to the prosecution. So firstly, in terms of the special measures in terms of the legal framework, like what Leilani had shared, Tuvalu also have foremost use the discretion of the courts, and that when we talk about the courts, we're talking about the magistrate courts being the lowest level of courts in Tuvalu, then the High Court and so forth, but the Court of Appeal and then the Privy Council. But normally most of the sexual offences or the prosecution of social offences initiate at the magistrate level or jurisdiction. Recently, we had amended our Magistrate Courts Act because we had just come into the reform with the abolishment or repeal of the Island Courts Act, which means there's no longer a island court, which is most of the district courts on the outer islands, and we've raised the jurisdiction, and so to support the many grievances or the many complaints in terms of no finality to cases at a lowest level of courts in Tuvalu. And therefore, we've raised the bar up to magistrate level. So when we talk about raising the bar in terms of magistrate courts, we are talking about moving it up to the standard of using the English language in the courts, expectation for written judgments at that level, and also the introduction, importantly, the introduction of virtual means for presiding magistrates, which is a plus given the remoteness of the districts or the jurisdictions of the courts widespread on the 8 or 9 islands of Tuvalu. So when we talk about the legal framework, I'm just going to touch base on the discretion of the courts, which often prosecutions sought leave from the court to request or seek leave for special consideration to those in need of special support when they give evidence in court, or even so during the pretrial phase of any proceeding in the court. So for the outgoing island courts, hardly any experience in terms of serious sexual offences being taken up there, but most of the sexual offences initiate or initially heard in this court, senior magistrate courts. And then thereafter will go directly to the High Court if there's any appeal. Otherwise, in terms of the different level of criminal offences, especially the sexual ones, it depends on the fact that in the past 40 years or 30 years to say, we did not have any resident judge. So now any other criminal offense or sexual offense higher than the jurisdiction for the senior magistrate court or myself would have to go to the High Court directly now that we have a resident judge in the country. But the special measures themselves, I have 3 points on my first part. Special measures provide a medium of support to bridge the existing gap between the information or the charge or statements of offense and the particular offenses. Especially in my experience sitting on the bench, there's a need for magistrates to draw conclusions on how far or to what extent would the court need or require assistance or guidance from prosecution on the level of support needed in terms of any vulnerable witnesses in need of support. Because if you look at how the information or the charge or statements of offense are being provided for, it's basically there's no assessment or a side note to indicate to the court that there's a special need from the court in terms of a initial information paper to provide background to the victim or to the complainant or the witnesses, list of witnesses when it comes to trial. So when we talk about special measure, the first note to take, or for myself sitting on the bench, is to ensure that once I receive the information or the charge sheet, I ask the prosecution for any other information, further information. Especially, we do not normally also use victim statements like other countries of the region. So it's quite challenging for a magistrate at the initial stage to continue with the taking of plea and so forth without the proper initial questioning of prosecution for assistance or guidance from the police prosecutor or the Crown prosecutor. And secondly, to develop and to invest in virtual courts. That's something that now with the reform and the amendment to Section 48 of our Magistrate Courts Act, by which magistrate courts have been given the discretion or by the directions to be able to appropriately use virtual means where it shall be deemed most expedient to facilitate the dispatch of the business of the court. So in this, there are two important aspects of the special measure coming in. One, firstly, is the assistance towards victims who are in need or who do not wish to be in the same room with the perpetrator or the accused person. So this virtual means supports the special measure provisions. And secondly, it does provide support given the remoteness and the scattered. At times there's a long delay because perpetrators may move from islands to islands trying to divert or to dodge the court proceedings. And with the virtual means, it will assist to the level of volume of cases and the backlog for the judiciary. So moving on, Section 5, subsection 5, in particular, the pretrial hearing in terms of the special measure provisions, thus support the work of the judicial officers in the sense that evidence gathered in pretrial stage is crucial. In the case of Tuvalu, we have a preliminary inquiry stage. And when we given the specific one-on-one or one-off, how do you say it? The CJ, the Chief Justice, giving power or expand the jurisdiction of a magistrates to hear specific cases, Section 5, subsection 5 of the provision really provides support, especially in my case. Any issue to do with rape or attempt rape, we normally are given expansion of the jurisdiction on a one-off basis. So the Section 5, subsection 5 really support for us to be able to thoroughly go through with the prosecution, especially in the pre-trial stage, to support or give assurance to the witnesses, especially the young victims who may have difficulties trying to attend or be part of a proceeding, of a proper proceeding. So in the absence of the perpetrator in pretrial, it's crucial that Section 5, subsection 5 is encouraged to be used in the courts of Tuvalu, given the need, the fact that most cases are on a one-on-one basis for the expansion or the extension of jurisdiction at this level. Given the smallness of our jurisdiction in Tuvalu, Section 8 of the Provisional Special Measures support the work of the judiciary in my country, and thus assist with safeguarding the interests of vulnerable witnesses, mostly at the pre-stage or during the trial time, as well after the decision has been made and the sentencing part or the phase. I think those are my comments for the first part of my discussion. If we look at Section 9, in addition, Section 9 talks about unacceptable questioning, as well the speeding up of the hearing. It does help with the fact that in Tuvalu we do face a lot of issue with the backlog, and therefore special measures in terms of the actual proceeding may assist the court, benefit the court highly. Those are the initial discussion for the first part. For the second part, in terms of how effective these measures are, it depends. One important and crucial aspect coming from the sitting on the bench is the importance for the court to know how the cases have been handled from the initial stage, that's from when the complaint was filed, to the interview stage, to the laying of charges, to taking of pleas in court and so forth. Because once special measures are not or were undermined at all those initial stage, there's no point in having a good hearing or disposal of a case, especially the discharge of functions of a senior magistrate like myself, because the defense counsel will automatically give or seek leave to indicate to the court of any initial challenges faced by the perpetrator. So in the case of Tuvalu, how effective are these special measures in our court proceedings? Not as much as what is expected at this moment, because at times I have to strike out or to give a ruling to take out certain cases, because defense have raised issues on the adherence to criminal procedures that were missed out by prosecution, especially some of those were the consideration into those provisions of special measure. But this comes quite often in the case of Outer Island Post, because it is operated and police by the police who look after the prosecution of case on the island, and that's very common to happen on the remote islands, especially where they sort of just take statements, interview, or lay charges, yet they did not give specific consideration to the needs to dial into the main island for defense support, especially in the case of child offenders being the perpetrators. So special measures would work well with the introduction of virtual means and also to the inclusion of virtual means in all steps of the proceedings. So prosecution should step up and amend the criminal procedure code so to cover all those special measures in the initial stage of any case, any criminal filing of a complaint, where there's a need for special support in terms of counselors at the initial stage, because our family protection domestic violence thus also provides specific reference to the needs, special needs at the initial stage of filing complaint. And when it comes to where I have to hear DV specific cases, often there's application under Section 45 of our Family Domestic Violence Act, given that the proceedings were not complying with what the Family Protection Domestic Violence Act have been providing the guidance for prosecutors, for Crown prosecutors and police prosecutors. Whether there's a need for further work to be done, yes. Importantly, it's not only about the special measures per se, but also the other framework, legal framework in terms of the provisions of the supporting laws of Tuvalu. For instance, when we talk about the domestic violence issues, we cannot separate special measures to be seen or checked or ticked off just because it's been covered under by the police at the initial stage. Yet we have to also consider other relevant laws that have provisions tapping into the procedures or the procedures that need to be followed. So special measures, when we talk about special measures, we also have to be considerate towards other provisos of other relevant laws that may be left out. So there's a lot of work for the fine tuning in terms of Evidence Act, laws, the criminal procedure, the penal code, because the penal code for Tuvalu requires also or expected to also cover sentencing in there, and thus it should be consideration should be given to juvenile or young offenders under special other special provisions of the penal codes that are outdated, and there should be consideration to amendments to those laws before we just talk about or just pick up on the special measures, because the courts, as you all know, look to the whole spectrum of from initial stage right to the sentencing, as well the aftermath, because we try to monitor and also support the perpetrators so they can change the lifestyle or the perspective in terms of coming back, rehabilitation into the community thereafter. Those are the comments I would like to state for the second part. But for the last one, where there's some questions from Nicholas, what impact has COVID had on the use of special measure in your jurisdiction? I think the first one would be the challenge faced. I'll approach it the challenge the judiciary faced at the moment is the reallocation of funds to prioritize other aspects of the affairs or business of the courts, and therefore special measures, although are being used in court, yet not as much as the keenness, because there are the priority in terms of the budget, and that comes with the COVID issue that we all experience, and therefore hardly have been applicable at the moment, the special measures, but most importantly, for Tuvalu, in terms of the virtual courts, that will be the support where special measure can be seen to be implemented in the absence of in support of the prioritizing of budget reallocation. For the second question, in terms of volume, what kind of special measures do you think are the most common in courts? Being a prosecutor before I become a magistrate, my experience in trials in terms of child victims in sexual offenses, the experience was that we use blockout screens just to ensure that some of these vulnerable victims being well assured. As well, not only that, I also have an experience with impaired hearing, with mental impaired, and thus the distraction was there with the need to have someone to come in to do the sign language and support. This was way back in 2017. And at the moment, coming now, sitting on the bench and looking back and hopeful the interest of those vulnerable or special measures or needs for those with impairments and those with special needs be realized in the judiciary. However, the challenge we have is that we don't have a functional court staff. We don't even have interpreters. So if we don't, with the lack in support or prioritizing of support to the judiciary system, thus put a challenge to how best we can implement the special measures. So in terms of volume, we'll normally just go with the screens, the videos, the recording, and now optioning for virtual means of support. But the basic support required and needed in terms of interpretation, the sign language staff, or the qualified counseling for those with mental impairity, it's still a fast stage for Tuvalu, but we hope to see improvement in that. In terms of the level of variation, may I just point out that it's not it's not too much of a specific attitude towards special measures, but it's a prior special measure issue we're facing, because for one, the number one challenge for Tuvalu, unlike Samoa in the sharing from Justice Leilani, we have 8 district jurisdictions, but from those 8, we only have 2 functioning court houses on those 8 islands. So we lack the necessary support infrastructures. We lack the staffing, and we also face a lot of difficulties in terms of budgeting, because we would like to have a full functional judicial system in the country, but the infrastructure level is still on the lowest, if I may say. So in the absence of those infrastructure and support, the special measures is something that we have to try to push through proceedings, but it is something that the attitude into special measure is highly supported. For instance, I'm sitting here in one of the room that's not the courthouse. The courthouse is on the other side. I'm using internet connection from a different aspect of the council or Tikapule. So you see, special measures will only be realized if we, Tuvalu and the government and the key stakeholders prioritize for infrastructure support, staffing support, the professional level to upskill, so to be able to realize the effectiveness of special measures in our court. But I would like to also say on the positive side of it that we have qualified magistrates now compared to the last 30 years. So it's a good step up for Tuvalu, and thus the reform in terms of the magistrate moving up the jurisdiction to the magistrate level as being the lowest or initial court of first instance really put Tuvalu to a big challenge, but we hope to engage through the partnerships with our stakeholders out here, as well from regional support, Pilon, AGD, JSB, the initiative from New Zealand and Australia. But otherwise, the government of the day really support the work of the judiciary, and part of the extension provided to support the work of prosecution, disposal of cases by the judiciary, and the all-round role of the and functions of the courts have been improved through this recent reform and amendments in our legal framework. I think those are my short discussions, I must say, but there's hope for Tuvalu, don't worry. We're here and we're learning from our big brothers and sisters, and we have a good, amazing team from prosecution who's here with us on the island. We came out for a court circuit, and we brought the defense counsel, assistant people's lawyer, the prosecutor, crown prosecutor, police prosecutor, and we were fortunate as of yesterday to witness the off-taking of the magistrates on this particular island. And we have the Honorable Minister of Education, and there you see government is in support of the judicial work and the overall prosecution, defense, and justice in Tuvalu. And that ends my short discussion. Thank you.
Thank you very much, Senior Magistrate Corina. That was a very interesting and informative presentation. It's been great to hear about the unique experiences in Tuvalu. Of course, the size of the population differs greatly to Samoa, so it's been nice to see the contrast between the experiences of the judiciary from Samoa and Tuvalu. So thank you very much for sharing that with us. I really appreciated understanding the needs of the senior magistrates in Tuvalu and how special measures might intersect with the need to draw conclusions on the matter at hand. It's also great to hear that you travel with the prosecution team and even defense counsel, and it sounds like it's a very collaborative effort in order to achieve justice in this area. So thank you very much for that presentation. At this point, we just begin with Jessamine, our graphic recorder, to see how our graphic illustrations are coming along. This is getting harder to read now, Jessamine, but it's looking great. There's a lot more information on there. Thank you very much for that. Thank you, Jessamine. So that now concludes the formal presentations today, and I invite those who have time to stay connected for a short question and answer session while we still have our Senior Magistrate Corina.
We have a question from Samoa, please.
Yes, please, Samoa, go ahead. Introduce yourself.
Hi, Corina. Thank you I'm Eileen Noah from the prosecution team in Samoa's Attorney General's office. I have my colleagues here. They're also in the prosecution team as well. Thank you for that lovely presentation, Corina. I was interested to hear that there's a lot of pre-trial hearings for special measures. I wanted to ask for an insight. Is that common to have pre-trial matters raised for special measures? And what are some of the examples of it? Because in comparison to Samoa, we hardly go to pre-trial for special measures because the judges are usually more leaning towards allowing prosecution to go on with the application or granting the application. But it'd be interesting to know some of the examples that go through the pre-trial for special measures in your jurisdiction.
Thank you. Thank you for the question and also for the interest in our pre-trials hearings. Normally, it's I was just showcasing the crucial link between pre-trial stage as per the provisions in the provisional for special measures. Normally, we have a preliminary inquiry into a case. So this is a stage where the courts will hear. This is normally for trial, in trial cases, especially rape, any other form of cases where there's a need for the initial or senior magistrate to prep up and transfer to the High Court. But preliminary inquiry into this aspect, thus the experience for Tuvalu when we do preliminary inquiry, we notice that that's where we realize or we find out that certain aspects or certain information from the case file have been left out. So for instance, when we talk about preliminary inquiry, we notice that a PW3 for the prosecutor is facing a challenge because she saw she was a witness, yet for her to formulate her evidence or to give evidence would be difficult because she have issues of hearing problems or something to do with her not being able to hear things, but she saw something happening. So when we during the preliminary inquiry, that's where all this the information about or background on the PWs or the prosecutor's witnesses come forward. And that's where the discretion of the judge or the magistrate, in this case, mostly is a senior magistrate, to question the prosecutor on the level of requirements or of the special needs for that particular witness. So in one of the cases where I was a prosecutor before I become a magistrate, I was not the prosecutor, I was the defense counsel, because at one time, how we share working with being in the People's Lawyer's Office and also being in the Attorney General's Office, being a prosecutor. So when we were dealing with this mentally impaired victim, she really needs support from someone who has the specific technique or knowledge of how to question her, because myself and the other counsel were unable to question her. So the need for a sign language specialist was required. Unfortunately, it was an issue that we have to wait for another 2 weeks or a week or so for someone else to come in and assist, provide that service. Also, when we were dealing with a child victim, having, like I said, the infrastructure is quite a challenge. So for the senior magistrate traveling to the outer island, and for the prosecutor, myself, that point in time, we have to use a house where it's just a normal house with a room where we put the perpetrator into, and brought the young girl into the sitting room, thinking that the perpetrator is not there. And she was so confident giving evidence. And after a while, she realized that we kept on looking towards that side. So she was asking the mother what's in there. Then she found out the perpetrator was being kept there. So in pre-trial hearing, we have to find out. It's important to use the special measures there. So we have special treatment for those who are in need. So child victims are often brought in pre-trial hearing, so they can be not coached, but be briefed or be forthcoming with the level of their competence to be giving evidence in open court in the real trial stage or not, whether they are not. So we normally just use the camera, and now with the amendment to Section 48, we will be going for that, and the courts will be pushing prosecutors to make use of those means. Did I answer your question?
Yes, very well indeed. Thank you very much for that insight.
Thank you, Senior Magistrate Karina, for that very detailed and very interesting example that you provided for that answer.
On behalf of Pelon and our colleagues from AGD, thank you for your time and support here from Tuvalu and from the Feathers Island of Nanumea.
Thank you. Thank you for that, Senior Magistrate. And I think that now brings us to the end.
Partnership. Sorry, some partnership in support to our humble and challenging journey to realizing justice in the small islands like Tuvalu.
Challenging but very important, and thank you for your work on that front. Thank you, Senior Magistrate Karina.
Thank you.
Well, I hope everyone attending this webinar that you found the presentations useful and has given you plenty of food for thought and how special measures could be used in your own jurisdictions and the importance of the judicial perspectives. For any of your colleagues that couldn't make it today, a recording of this webinar will be circulated to all attendees along with the finalized posters from our graphic recorder. You can also find the recording plus earlier webinars in the digital library of the Pelon website. We will continue the important discussions at our final webinar on this series. Our final webinar will look more closely at another important viewpoint, which is the victim support officers. In the meantime, I encourage you all to look for opportunities to collaborate with your colleagues across the region. We will be sending out a very short survey after the webinar and would be really grateful if everyone could use it to provide feedback. A link to the survey is now in the chat link. We thank everyone who took the time to provide such thoughtful feedback about the first two webinars as well. This really helps Pelon and our working group improve our training in the future. If you would like further information or assistance with the implementation of special measures in your country, please provide your contact details in the survey. These requests may be considered, and the Australian Attorney General's Department may get back to you on that. Alternatively, you can email the Pelon Secretariat and we will ensure you get the information you need. I wish to thank both our wonderful presenters today. It has been a real pleasure having you with us, and we wish all our participants a great weekend. We look forward to seeing you at the final webinar in this series. Please keep an eye out for a save the date email from the Pelon Secretariat on that. So thank you. Have a lovely weekend. So far, so good.